Good evening. Welcome. Welcome and thank you so much for being here. It's wonderful to see the group of experts that we have assembled here in this room. And thank you also to all of you who are joining us from remote locations. I want to say I am Catherine Loving, Chair of the Election Law Committee at the New York City Bar Association. And I want to thank our speakers and also a thank you to our co-sponsors. If you look into the agenda, which you were sent earlier today, there are the priorities of each of our co-sponsors are listed here in case you're interested in looking at them. And now it is my great honor to introduce the president of our association, Sheila Boston.
Thank you. Well, good evening to everyone. Let's warm up a little bit. I'm gonna reach out to you and I need you to talk back at me, okay? So let's try this. Good evening. Thank you, wonderful. I am so delighted to welcome all of you to the New York State Election Reform 2022, the 3 most important things. Now, this is a hybrid event, as you know, and I'm so excited and certainly want to welcome all of those who are joining us virtually. I see you, and I'm so delighted that we are in the house, everybody. We are in the Bar Association house. Let's give a hand for that, yes. I certainly wish to thank our Election Law Committee for conceiving and developing this crucially important program. In particular, our chair, Catherine Loving, thank you so much for her tireless dedication to our topic for today. And yes, let's give her a round of applause. She worked hard. A big thanks as well to our co-sponsoring committees, Government Ethics and State Affairs, New York City Affairs, and the Task Force on the Rule of Law. I also want to thank, incredibly, our wonderful City Bar staff. By the way, I call this the Bar of Hope. That's my nickname for the bar. I want to thank all of you staff, Kevin, who's been working on IT, and all the staff who might not even hear my voice right now because you are some of the hardest working folks. And I want you to know you work behind the scenes, but you mean a lot, and we're thankful for you. And finally, a big thank you to all 15 co-sponsoring organizations, which in the interest of time, I'm not gonna name them all, please do not be upset with me, but I want to say their participation is significant. And it speaks to the rightful concerns in our communities about the integrity of our election systems. All politics is local. That's how the well-known saying goes. Well, we could debate whether that's been changing lately, but that's for another program, I think. What I think we can say, undeniably, is that all elections are local. Whether it's for citywide, countywide, statewide, or national-wide office, our democracy depends on the smooth and proper functioning of our electoral systems on the local level. And it's no secret that we've had our issues, yes, even right here in New York. And of course, that's why we're all gathered here today. And it is incumbent on us to clean up our own house. If we were in the church, somebody would say amen about that, just saying. How important it is, or how important is it to ensure the smooth operation of our local electoral systems? I think it's not too much to say that the rule of law and democracy in America depend on it. When I began my tenure as City Bar President in the spring of 2020, I announced that protection of the rule of law would be one of the 6 pillars, the priorities, if you will, for the City Bar to focus on at this time. Per my request, the City Bar's Rule of Law Task Force and Election Law Committee graciously accepted the challenge to create a written product that educates, calls for federal legislation, and serves as a call to action to the entire legal community to serve in a central role in the protection of voting rights in this country. The culmination of legal expertise and hard work of these 2 committees is a report entitled The Consent of the Governed, Enforcing Citizens' Right to Vote. And it's available to all of you on the City Bar homepage. Please check it out. It's a wonderful piece of work, and I really urge you to read it and share it with others. And I hope that everywhere across the country, programs and conversations like the one we're having tonight are taking place to optimize voting systems everywhere. And you know what? We owe it to all the local election officials and all of the poll workers who do their often thankless tasks, that so important work. They are nothing less than our latest category of heroes and sheroes, considering the spotlight that's been placed on them, and worse, even the threats they've had to endure. It is critical that we not hand any support to those who would cynically question the integrity of our elections. And with that, I thank you once again for your attention to this matter. And it is indeed now my great pleasure to turn over to our moderator, Brigid Bergin, Senior Political Correspondent for WNYC and Gothamist, who will introduce our extraordinary panel to get this conversation going. So Brigid, I thank you so much for being here today and moderating. And now I pass over the mic to you.
Thank you so much. It's not often that I feel like someone can compete with my enthusiasm talking about election law unless I'm in a room like this, in which case I feel like there's a lot of energy, a lot of enthusiasm, and a lot of interest and a lot of expertise. I want to welcome our panelists who are both here in the room and on Zoom. For our panelists who are on Zoom, I'll just give you a heads up that I may give you a few cues about our timing because we have some great volunteers who are helping us keep this conversation moving. But I'm very excited to hear all the expertise people have to share. These are people who I frequently call for the reporting for the work that I do. And if I haven't called you yet, now that you're here, I'm going to start. But I want to jump right into our conversation. And we'll start with our first speaker. We'll introduce speakers as they give their presentations. I'll ask a few follow-up questions. And at the end, we're going to have some additional time for some hyper-informed questions from some of our guests here tonight. And I'll be keeping an eye on the Zoom to see if anyone adds a question into the chat. But to start, I will introduce Doug Kellner, co-chair of the New York State Board of Elections, who will be our first speaker tonight. Doug, I'll let you take it away. Make sure you hit your button when you are speaking.
All right, well, thank you, Brigid, and thank you all for being interested in this vital issue. The Democrats took control of New York State government after the 2018 elections and hit the ground running to implement changes that the party has been pressing for decades, and which when they had that brief 4-month interlude with the control of the Senate in 2010, they started with a very particular agenda where they didn't just run and put everything in all at once. And it came as a shock when come April, they lost control of the chamber. And the leadership vowed that they would not let that happen again. And in the last 2 years, there have been more than 80 bills changing election procedure in the last 2 years. And we've seen the introduction of early voting. We've seen the change in the election calendar. We have seen the adoption of public campaign finance. And I'm sure I'm leaving out others. But huge changes in election administration, frankly, huge burdens on the Board of Elections, adding, dealing with the problems of running elections through the COVID epidemic. And these programs have been introduced well, and that local election administrators who've had to do most of the work on these deserve some credit for them. But yesterday, Senator Myrie and the Senate Election Committee issued what I thought was an excellent report that says we're not done yet. We've still got many issues that need to be addressed, and we're not finished with the reform process. I'll also add that there was another report a few weeks ago issued by the Brennan Center on the New York City Board of Elections. And both the Brennan Center report and the Senate election reports, I think, contain numerous meritorious proposals, although I can't say that I agree with every word in each of those reports. Now, since I am the chair of the State Board of Elections, I guess I need to take some responsibility and to say, yes, I am part of the establishment, and I hope that I'm working to find solutions and that I'm not part of the problem. But just to report on what the current priorities are, we have just appointed a new Democratic co-executive director of the State Board, who's really the one who does the work implementing our programs. And I would characterize her work now, and that's Kristen Zabrowski-Stavisky. And I would characterize Kristen's priorities as three main areas. One is to complete the online voter registration program and ballot tracking systems that the State Board has been working on, and is a major project and is swallowing up a lot of time and resources at the State Board. Second is the really big project, which is the introduction of the public campaign finance program, which goes live in November of next year. So we're just 1 year away from when the cycle begins, and will be used for the 2024 elections. And I emphasize that this new public campaign finance program is huge in scope, because the number of offices it covers are more than 3 times the number of offices covered by the city campaign finance program. And we have statewide legislative elections every 2 years rather than the 4 years that the city campaign finance board works on. And I could talk about lots of issues in implementing that. The third priority going on at the State Board is better oversight of the local boards of elections. It's more of a wish than a reality, given the fact that the current budget only has 3 staff people assigned to deal with the 57 county boards and the city board of elections. So it's certainly something that we think is appropriate, but Kristen is working with the Republicans to revamp the current oversight program and to at least lay out how we would do it if the legislature is true to the Senate report and provides for more state responsibilities for training and oversight. Now, given that, I'll still run through what I regard as the big problems with the New York City Board. I'll start off by saying that I think they did a good job in implementing early voting. They did a good job in implementing ranked choice voting, even though there was the one kerfluffle with the early reporting of unofficial election results that were obviously flawed. But overall, it was a big each of these were big projects, and each of them they did well. But I'll still say that I'm not satisfied that they've finished implementing early voting. The state law requires the use of vote centers where anybody can go anywhere in the county in order to cast their vote. I find it unacceptable that the city has thrown up their hands and said, well, that's all we can do. There are limitations that keep us from implementing vote centers. Those limitations are not deal breaker barriers. They just have to get off their butts and work through what they need to do to implement the program properly. Long-time issues that I continue to raise are that they still run election day poll sites with a one-size-fits-all model. They need to get out of that. They need to run election day poll sites the same way they run early voting poll sites, with much more efficient organization. And I could go on and on about how to reorganize these poll sites. They know what to do, but for various reasons of inertia, the city board has resisted doing what they need to run poll sites more efficiently. My biggest grievance is their lack of implementation of the 30-minute rule for presidential general elections, and that's because they treat presidential general elections like everything else, even though the voter turnout is much greater for presidential elections. And then the city board has inherent structural problems because of the current 10 commissioner model. The Brennan Center report laid out many of those problems, which I wholeheartedly agree with. And my solution is to go to 2 full-time commissioners like the other 57 boards in the state. We could talk about how to choose those 2 full-time commissioners, but the bottom line is that you will have better accountability if you have 2 full-time commissioners, 1 Republican and 1 Democrat.
I'm going to jump in. Thank you, Doug. I have the opportunity to jump in here with questions. Welcome, Susan Lerner. We're going to introduce, as I said before, all of our speakers as they do their presentations, but since I have the opportunity to moderate, I get to follow up with a couple quick questions for Doug. Doug, let's start with where you left off, which is we could talk about how you, if we were to reorganize or reimagine the Board of Elections and only go down to 2 commissioners, how would you do that? I imagine that that is one of the biggest obstacles to starting the conversation of structural reform is the borough fighting that I can imagine ensuing. So how would you do that?
Well, I would do it with 1 Democratic and 1 Republican commissioner. I think the easiest way to do it is to provide for the state committees to set the rules for selecting those commissioners, and they should be approved either by the city council or some other combination of the mayor and the city council. But I think that the current selection process has inherent structural flaws in providing for accountability and for giving the people who are in charge, meaning right now the executive director and deputy executive director, the ability to recruit the most qualified staff, and that we have to end the fiefdoms of senior management staff at the City Board of Elections, which operates, in my view, as dysfunctionally as the fiefdoms of the government of Lebanon right now.
Okay, Doug, thanks for that. Let's move to our next presenter, who is going to be one of our virtual presenters, Professor Michael Morley from Florida State College of Law. He's the Sheila McDevitt Professor. Professor Morley, are you there?
Yes, hi, thank you very much for having me.
Welcome. I will let you dig into your presentation.
Great, thank you very much. So my presentation today is going to focus on two main issues as we think about ways of moving forward to improve the electoral system, possible reforms that the legislature could consider. One of the most important areas of my own study has been election emergencies and election emergency statutes. Obviously, this became a high priority issue this past election cycle with regard to COVID, where many states, or all states, including New York, were forced to adjust their electoral systems in order to accommodate the risks that COVID posed. Many states that historically had very low absentee voting rates in particular expanded their eligibility for absentee voting, expanded their capacity to deal with absentee voting, and in many cases actually saw many times more absentee ballots cast than were typically cast in past elections. One of the main things as we think about emergencies, and again, we just lived through a pandemic, but we face very different types of crises. When you think back a few years, New York was hit with, I believe it was Superstorm Sandy as it was approaching Election Day. An election emergency can then take the form of the 9/11 terrorist attacks, as you might remember, occurred on the day of the New York Democratic primaries. Different types of emergencies pose different types of challenges to the electoral system, whether it's a natural disaster, a terrorist attack, it could be a widespread power failure, it could be something like a national postal strike or some sort of interference with the postal system, it could be a pandemic. Depending on the type of emergency the system is facing, the most appropriate types of responses will differ greatly. Now, New York, in one respect, has a very unique election emergency statute that says if a natural disaster prevents people in a particular jurisdiction from voting, that if the turnout within that jurisdiction is a quarter or less of the registered voters in that city or town or county, as a result of that disaster, then an additional day of voting can be authorized. In many other respects, however, rather than having election emergency specific laws that delegate authority to election officials to make certain sorts of adjustments or modifications to the rules governing the electoral process, instead the state of New York is forced to rely on its general state of emergency law that simply gives the governor authority to suspend statutes or to suspend statutory deadlines during declared states of emergency. Rather than just relying on that catch-all fallback authority, many states instead have more specific election emergency statutes where the legislature decides the type of changes that are appropriate, the types of changes that should be triggered in emergency situations, whether that's extending certain sorts of deadlines, suspending certain types of requirements. It could be anything from allowing greater flexibility in terms of how votes are cast, in terms of eligibility to cast absentee ballots, the requirements for casting absentee ballots. And so by having election emergency specific laws, on the one hand, the legislature gets to make those policy determinations. The legislature, as a matter of statute, gets to, in a sense, pre-authorize certain types of emergency responses. And just as importantly, the legislature can identify what I call election emergency red lines, certain types of steps that even in the course of an emergency should not be authorized. So the legislature might decide, for example, that given the current state of technology, authorizing internet voting, authorizing people to return their ballots by email, for example, is simply too risky, that even during an emergency, we don't want to open ourselves up to those steps. And so by having an election emergency statute, you can not only authorize certain types of responses, but actually take other types of responses off the table. The other main issue that I had wanted to briefly touch on is the notion of equal protection principles as they apply to election administration. One aspect of election administration that's been getting more attention from courts lately, that certainly was the focus of a substantial amount of litigation during the 2020 election, is that where you have multi-jurisdictional elections that span multiple counties, even statewide elections, the extent to which we can continue to have materially different rules apply within different counties, right? Traditionally, American elections have been very decentralized. Traditionally, local election officials and county election officials have had broad discretion to adopt their own policies. Over the past 20 years, we've seen lower courts start to apply what I call the uniformity principle of Bush versus Gore, the notion that you can't treat different, you can't have what the court said was arbitrary and disparate treatment of voters participating in the same election. And so we've started to come to see that principle apply to more and more issues of election administration. And so that, to the extent that avoiding equal protection concerns is a priority, that would tend toward greater centralization, greater uniformity of election procedures, rather than the traditional decentralized delegation to county and local officials that historically has been the case. And so again, this is simply the beginning of a trend. We're starting to see more litigation along these lines, more court holdings along these lines. There's still a lot of development in the law, a lot of play in the law. Over the years to come, I expect we'll get even more clarification on these issues from the courts and potentially even the Supreme Court. Thank you very much.
Thanks, Professor Morley. So many interesting topics in that, and listening to what you're explaining and then thinking about what Doug was describing in terms of how we think about the City Board of Elections as compared to the State Board of Elections. I'm actually wondering, Doug, about your reaction to some of what Professor Morley was saying in terms of what he was raising with the uniformity principle, and to what extent, when we think about how we are imagining election reform here in New York State, is that something that would apply as we think through some of the changes that we can envision, and to what extent is New York City an outlier to the rest of the state?
So they make good points, and it's something that everyone talks about all the time, which is to what extent do we want uniformity over local options and dealing with local conditions. But I will say one thing that came to mind during his talk was in New York, I thought we did an outstanding job dealing with Superstorm Sandy, while New Jersey completely screwed it up. At least the way we've been working with the governors in the last decade tells me that the emergency procedures work reasonably well, even though it's been frustrating to deal with the governor's office to get the executive orders on many occasions. It worked reasonably well, in my view.
Professor Morley, where would you say there are models of emergency election laws that we would turn to as a model? Are there states that are doing it particularly well? You know, we are patting ourselves on the back in terms of how we were able to deal with an emergency here in New York, but given the way you described that specific type of law, where would we look to see where those laws exist well?
And I would also begin, by the way, by echoing that's absolutely correct. But New York did have a great response to Superstorm Sandy. New Jersey's response raised several legal issues, and in fact triggered some litigation over the emergency orders that were issued there. In terms of models, I think that Virginia and Florida both have fairly fleshed out election emergency statutes. None of them are 100% comprehensive, but whereas New York's main election emergency statute is about having, in a sense, a backup election, right? That if an election goes horribly awry, if you have just a tiny fraction of the electorate turning out, New York law authorizes holding an extra day of voting, and then gives the governor this general just fallback authority to suspend whatever laws or statutory deadlines he or she deems necessary. Virginia and Florida are more focused on empowering election officials to make decisions, to modify particular rules, to change particular deadlines, to suspend particular requirements in order to try to have the election as scheduled go off as to the greatest extent possible, to facilitate the greatest participation possible, and to have this be laid out in advance rather than having to work it out with the governor's office and have it potentially even be more of a political issue where the decisions are made without statutory guidance, without statutory restrictions, as opposed to the system in Virginia and Florida, where there are more standards and boundaries laid out in the statutes themselves.
Professor Morley, I think you started to hit on this, but what is the counter argument to these types of laws? What are the risks that they pose, and why have states not implemented them? When you listed Florida as the model, that kind of surprised me. But I don't know a lot about Florida state election law. So what have opponents of these laws said in the past?
I don't know that you really necessarily see opponents of the laws per se, so much as they tend to be more of a recent development. Florida got hit by a very bad hurricane in the midst or imminently before an election, and that triggered the enactment of an election emergency law simply because it lacked the legal infrastructure necessary to allow election officials to be able to respond to that sort of crisis. So I don't necessarily know that there's much institutional pushback against the laws, so much as unless and until a jurisdiction has faced a natural disaster or has faced a crisis, it just wasn't seen as that high of a legislative priority, right? It's more of, well, what are the odds a disaster is going to happen on election day? Or what are the odds a disaster is going to happen right before election day? I think that as we see election day turn into more of an election period in many jurisdictions, right, where you have a longer period for early voting, you have a longer period for absentee voting, and certainly as you see elections get more subject to litigation, right? What Professor Rick Hasen calls the voting wars. I think that having the rules laid out in advance, having officials' discretion laid out in advance, rather than just a fallback to the governor saying just suspend whatever laws you think are necessary. I think that just given how more hyper-partisan the political process has become, how more hotly contested and litigated the electoral process has become, I think we will see a trend toward more election emergency statutes rather than just complete unlimited gubernatorial discretion. And I think that certainly if you look to our experience even with the 2020 election, states that had robust emergency statutes, whether election emergency specific ones or broad state of emergency ones like New York, did a lot better than states where the statutory ability of either election officials or the governor to respond to COVID, to make adjustments to COVID, was much more limited, was much more cabined. And so in some cases, you had emergency measures being struck down by courts, saying that the governor didn't have statutory authority to take those actions. So by having these laws enacted in advance, you help to avoid that type of uncertainty, minimize unnecessary litigation, and perhaps most importantly, you have election officials with expertise in the system who understand the system be making the decisions rather than in the extreme case, courts doing so but sometimes ex parte proceedings, TRO proceedings by generalist judges who aren't as familiar with the nuances of the electoral system or the potential downstream consequences of particular emergency orders. So you don't want to leave courts in the position of having to deal with these last minute emergencies. You'd rather have a statutory infrastructure that ideally allows the election officials to do so.
Thanks, Professor Morley. I want to turn to our next speaker, someone who I think this room knows very well, Martin Connor, an election lawyer, former minority leader of the New York State Senate, I believe former chair of this committee. if I remember correctly from Catherine. Take it away.
Thank you, Brigid. Let me say something in general. You know, and I suppose any professional athletic team or professional athletes in New York City will understand this, but the New York City Board of Election is constantly being criticized in the press and criticized by other elected officials. It's everybody beats up on the City Board of Elections. And it's not that there aren't some things, as Doug pointed out, that could change, and some things that should be fixed. But let me tell you what I've heard, because I've been in boards of elections all over the state, as well as the State Board of Elections. And I've heard from people who deal with state elections, people in Doug's shop, Democrats and Republicans, who are upstaters and say to me, Marty, they're always beating up on the New York City Board of Elections. It's actually the best, and this is not a good fact. It's the best local board of elections in the state. And that's not good news for the state of New York, believe me. And you know, everybody got excited. I don't get so excited about an unofficial release of some numbers that are wrong. It's unofficial. Maybe the press doesn't like it. I understand why. But, you know, that was never going to carry over to the final result. Not in a million years.
I don't think the candidates liked it either, though.
Pardon?
I don't think the candidates liked it either.
Well, I understand. People get all upset about unofficial results, you know. But in that Brindisi-Tenney thing, and I was obviously one of the New York attorney for Brindisi, astounding things. County boards of elections certifying to the court, we've counted every vote. No, the 3 days later, oh, we found some more in a drawer. We didn't count. You know, somebody saying, well, we just couldn't get to process 2,500 timely voter registrations. A county board that said, oh, you know, we didn't count any affidavit ballots on the statewide transfer. We couldn't do that. You know, it was too hard. Now, you have to understand, when the legislature rapidly adopts a lot of reforms, there is an administrative burden placed on the local boards of elections. And I go way back to when I was in the Senate, and I was one for my conference negotiators with then Governor Spitzer's council, when they were going to have all the local filers, candidates filing their campaign finance things with the State Board of Elections. They added thousands, Doug could tell you, thousands of filers to the state board. And I said in those meetings, well, you got to give them resources. And actually, Governor Spitzer's answer was, we put in the budget another $20 million for the State Board of Elections. They're still waiting for it. The next year, division of the budget, the governor, you know, there goes the $20 million. In my 31 years in the legislature, every year at budget time, groups would come up. We don't cut this money. We need more money for seniors. We need more money for daycare. We need more money for education. We need more money for this. Never had any people show up in Albany and say, we need more money for election administration. And now you're putting on a state board. I mean, you'll get some good government groups. You'll get, I'm sure Doug and the state board says we need more resources. But, and I never heard of a legislator going back to their district and people yelling at them because, oh, you didn't fund elections sufficiently. They will get yelled at for not funding other things. And that's a problem because it really cuts to our democracy. Let's face it. People don't realize upstate board of elections, most counties have 2 commissioners and 2 deputies, 4 people. I've been counting votes in a county upstate under court order in a special election for Congress, where the judge ordered them 12 hours a day to be counting votes. They had 4 people there. One of the people, it takes 4 people. You're moving ballots in and out. You had lawyers on both sides, lawyers from New York, lawyers from Washington at the same time. But one of them would say, excuse me, and have to run to answer the phone because there was nobody else to answer the phone in the Board of Elections. And in comes some county official and starts yelling at the commissioner because some routine monthly report that county agencies had to hand in had been due 3 days before, and you're going to be in big trouble, and we're going to cut your budget. Why isn't that report in? And the commissioner's trying to explain to this guy that, well, we're under court order. We're counting votes. I don't care. That report's due on the first day of the month. Okay? That's what we're dealing with. Back when I was on the voting machine commission that we set up in the 80s, I proposed as one of the things. That commission, the main thing it accomplished is we actually abandoned the punch card voting and said it couldn't be used in New York. This is 6 years before 2000, and the whole world heard about hanging chads and that kind of thing. But I proposed, hey, why doesn't the state should fund election boards? Because if they're dependent on the local government for elections, they're not going to get a lot of money up there. They can't just go to these small county governments and say, oh, the legislature just passed the bill. We have to have electronic poll books. We have to have early voting. We have to do this and that. Could you give us money for 4 more people to work at the Board of Elections? They're not going to get it, and they didn't get it. And I don't think those 8 counties in that Tenney-Brindisi fight, I think they're typical. I think all the horror things that came out is happening all over, and nobody's noticed. Nobody would ever notice any of this stuff. It wasn't a close election and got lawyered up. You know, the Oneida County Board, 2,500 people would have been totally disenfranchised. And nobody would have known about that disenfranchisement. And they never would have counted it was 800, 900, 1,000 affidavit ballots. You know, when we started getting copies of them and they said, not valid, registered in Albany County or registered in Bronx County. And you're like, wait a minute, they're registered. It's an automatic transfer. So my number one thing I have to tell you is budget, resources. You're now setting up a public financing system, as Doug pointed out, much bigger down the road than the New York City one. New York City Campaign Finance Board has a lot of staff. Is the legislature that adopted this ready to give them 100 staff members so they can have audit everything? Right now, they're proposing random audits. And if you're audited, we won't audit you for, you're off the hook then for the next 3 times. It's an invitation for wrongdoing. It's an invitation. We're talking about millions in public money. And there will be people gaming the system. We've certainly seen that in New York City, but they get caught. They generally get caught because the city Campaign Finance Board has enough staff that they audit everybody after every election. A random audit doesn't work here. People will figure, I got audited, good. Now I can do whatever I want for 3 years because they won't audit me again. I'm off the hook. So that's my number one thing. Number two, as these reforms go out there, the sexy issue gets passed and nobody, it seems, in the legislature is looking at what's that mean for other provisions of the statute that are related to that. Prime example is, okay, we're going to a June primary. Oh, we're going to have a zillion absentee ballots, but we still have a 10-day, and they call it a statute of limitations, but in election law in New York, it's actually a grant of subject matter jurisdiction to the courts. It can't be waived. And it requires filing and service before the period. And for primaries, we have a 10-day statute. But because of changes like lots of absentee ballots can be received up to 11 days after the election, postmarked by primary day. And the cure thing gives you another thing, so that they don't have all the ballots in hand for until 22 days after the primary. So everybody's saying in 2020, why are you all bringing court cases? We don't know what's going to happen. 50% of the votes in 2020 in the primary were on absentee ballots. And you had to tell your client, look, if something goes wrong, I can't do anything about it. If you don't bring this court case, we don't know what's going to happen. It's stupid to say you have to go to court by 12 days before you even know how many ballots there are and they start being counted. Why is there a 10-day statute? Nobody thinks about this. When I started doing this 50 years ago, there was no such thing as an affidavit ballot. And there were no absentee ballots allowed in a primary. So you had your primary, you 3 days later went to the warehouse, looked at the machines, got the numbers and decided, do I go to court or not? You still had a week to go to court. The world's changed, but nobody's looked at that. And I know that's not sexy. No good government groups yelling about the statute of limitations, right? But
surprise, surprise.
It doesn't make any sense. It's nonsense, but people are bound by it. Thank you.
Thank you, Marty. I think my first question, and I say this because our next speaker is someone who could actually help address the issue you raised, which is the budgetary issue. We have both Assembly Member Latrice Walker and State Senator Zellner Myrie on this call, who play a role in deciding that state budget where we could get some of the money that you're talking about. But you were a lawmaker for many years, and you described some of the obstacles that come up during that budget process. But what are we talking about here in terms of what kind of, how much more do these state boards need? Should it be something, should financing for these local boards be coming from the state instead of local jurisdictions? How do we begin to solve the problem that you've identified?
I think we have to. One, you know, if you read the statute, the State Board of Elections actually does have supervisory authority over the county boards. It's never really exercised in the way the statute reads, because one half of the board, not Doug's half, has always said it's a local thing, leave them alone. So instead they issue advisories instead of directories. Instead of saying you must do this, they say, we think you ought to whatever, or we recommend whatever. They should be able to order them. The statute says whatever, follow the law. And they should have the staff to monitor that. And as Doug pointed out, they have 3 people for 57 boards. Hello. So, and now you're talking about the campaign finance thing. I mean, they need lots more money. And I think I mentioned, I once got them $20 million that the division of the budget decided not to pay to them. And there's no hue and cry about that. You know, if the division of the budget decided they weren't going to give $20 million to a school district, there'd be a hue and cry, there'd be pickets, there'd be letters written, and there'd be a political price for the legislators who didn't actually get that delivered to the school district. Nothing happens when boards of elections get squeezed. And I think what the answer to your question is, I think going back to what I recommended, and believe me, that Governor Cuomo was Mario, didn't want to hear about the state paying for elections, but I think the state should fund all the county boards of elections. They should beef up big time the State Board of Elections so that they can actually supervise them and in effect implement a statewide system. Yes, local people will be the commissioners and the staff and the local boards, but they'll be part of a unified whole election apparatus. I think that's the only way to do it, and the only way to make sure, a vote in Shenango County in a close statewide election is the same as a vote in Brooklyn. You get all upset in Brooklyn if they make a mistake, and nobody pays attention to Shenango County.
Fair enough. Can you turn it? Thank you so much, Marty. I want to turn to Assembly Member Walker. Are you there?
Hello. So I want to say thank you so much to the New York City Bar for having me. And of course to Marty Connor, Senator Connor, with his infinite wisdom. It's always a pleasure to participate in this type of forum with someone who you consider to be a real hero on this issue. It's also a pleasure to be here with the other experts, as well as my colleague, Senator Myrie, who is a true partner. I am sort of new to the chair of the committee, and so it's been an awesome experience to be with someone who is so progressive minded. And so, I started out as an election lawyer who saw a number of issues that were facing not just myself as a candidate, but so many other individuals that I worked with. And so to sort of piggyback off of the theme that I've heard is that the road to hell is paved with good intentions. And so I, in my position as chair of the Assembly Election Law Committee, I kept hearing in my head PAVE. And so I came up with a PAVE agenda, which involves protections, access, and voter education. I believe that voting should be easy, accessible, and efficient. And so there are 5 main priorities that we've looked at and will continue to look at. One is to ensure the voting rights of all New Yorkers. With Senator Myrie, we worked together on a voting rights bill, the John Lewis Voting Rights Act. As we're going through our redistricting process, we see how important it is for us to have a pre-clearance provision to ensure throughout our redistricting process to ensure fairness, justice, and equity in redistricting, as well as in all of the voting apparatus. The second thing is to modernize our voter experience. We also believe that it's important to protect the election process from vulnerabilities and cyber attacks. And then to go back into what Marty said, we have to advocate for the capital and operational resources to realize those goals. And in that effort, this year in the state budget, we've allocated $25 million in capital. 20 million of that will go to the local board of elections based on the number of registered voters in each county. We're also allocating $1 million to state operations. So we have the capital that's coming in, but also the operational resources to make it happen and to do the necessary hiring to make sure that the administration of elections sort of follows suit to the goals that we are all seeking to achieve. And then lastly, early voting is upon us, and it's always a conundrum in terms of where we're going to locate these sites at and who's going to man them. And so there's an additional $2 million in this year's budget in order to do the administration of early voting. And of course, we can also employ some voter education in this system. We have to do a lot more poll worker training. We've introduced bills with respect to training and curriculum. We've allocated or allowed for the ability of people who are presently on parole to be able to register to vote and to vote. We have to ensure that they are educated and that the Department of Community Corrections and Community Supervision have the resources that they need to make sure that those individuals are actually participating in the franchise. We have to think about the experience of people who are disabled in our state, as well as language access. I know I heard Doug talk about the administration of automatic voter registration and online voter registration. And then language access is a real issue, and there's certain languages that are protected, and there are some which are spoken with a certain level of regularity, like Haitian Creole, which is not a protected language, but we need to make sure that those individuals who speak these languages, Bengali, et cetera, are also included in the ease and exercise of the franchise. Absentee ballot, we saw a huge, situation with respect to that, not just on this year's ballot proposals, but in the previous elections considering COVID. And so we have implemented and passed bills in order to make that administration a lot more reliable with ballot tracking, and as well as a system where we will be looking at the online application for absentee ballots as well. The fact that we weren't able to get the no excuse absentee ballot, as well as same day voter registration across the finish line for the constitutional changes that we need, we're going to go back and make sure that we're able to do that again. But it's also worth noting that even in this instance, if an individual wants to request an absentee ballot, that illness or the fear of illness or anxieties, et cetera, will still qualify for an opportunity for someone to request an absentee ballot. And in addition to that, I know we were, really concerned about the time period before a person is able to register to vote. The Constitution still allows for 10 days. So we have a little wiggle room in there in order to, go down to that 10-day period. So again, as I mentioned before, about the road to hell being paved with good intentions, but now I believe with this PAVE agenda that we are continuing to pave the way to progress, and I look forward to working with each and every one of you in this lofty election law agenda and experience that we have before us. So thank you, and I'm Assemblymember Latrice Walker.
Assemblymember, thank you so much. You said one of the points you raised was modernizing the voter experience. Can you talk more about what you meant by that?
Well, the online voter registration is definitely one. Like, we are able to do our banking online. We are able to, set up doctor's visits. I mean, the internet and our cell phones, and of course the access to broadband is a really huge issue there. But there's so many different things that are at our fingertips, so that our voting experience should be just as easy as it is to be able to do almost everything else, which is considered, everyday life as a voter. And so it's important for us to be able to do that. We are looking at different election law machines in terms of the administration there. I would love to see on-demand ballot printing. We are having conversations about the right church, wrong pew conversation, where individuals show up to a poll site and they might be in the right assembly district, but they're in the wrong ED. And so when that individual shows up on election day, they should be able to get an on-demand ballot, notwithstanding who's on the ballot, so that they're not limited in who they are able to vote for. And so those are just a few scenarios that we are going to be, sort of working through. Let's say even with automatic voter registration. I remember when we first started that conversation, it was about, just looking at DMV. And we were having conversations that could be tantamount to a voter ID law, because only people who are going to DMV are people with IDs or, access there. And so when people are going to register for NYCHA or going to HRA to handle whatever those circumstances are, they are automatically registered to vote. And, the only way that they're not registered is if they say that they don't want to be. And so these are some of the dynamics that we're dealing with in order to modernize that experience, bring us into the 21st century. And as we heard before, it may have taken us 400 years to get here, but it's going to take us an eternity to reach the promised land, if you will, with respect to voting.
Assemblymember, you held a hearing this summer in Brooklyn about the experience of New York City voters with the first ranked choice voting primary. I wonder if you could, it's a city issue, obviously, but I'm wondering what made it something that your assembly committee decided to take up, and what did you take away from that hearing?
So there are a number of bills that are before the assembly with respect to a statewide experience for ranked choice voting. And we were looking at the circumstances which took place in California and other places where there was ranked choice voting, including right here in New York City, where the local school boards used to be decided in that way. And one of the things that, as we were having conversations and going along with our educational campaign, we were finding that there were too many people who were saying they didn't know what this was, that there just wasn't enough information about it. Who do I vote for? How do I do this? And so I believe that it was important enough for the Assembly Committee to be able to look at the things that went right with ranked choice voting in order to perfect upon that, if it does come to that, as well as to look at some of the pitfalls and mistakes that were made, like the unofficial reporting of numbers. I didn't believe that the City Board of Elections was ready in order to handle such a huge task. I 100% didn't believe that they had the resources that were necessary in order to effectively and efficiently administer this situation. And what I saw was that's exactly the case. Many individuals, as we've seen in different reports, including that of Assemblyman Brennan, who I think did an outstanding report about this issue, that many people were still bullet voting. And we believe that, maybe there could have been a little bit more that was done in order to ready the electorate to be able to handle this huge change. And so hopefully we'll be able to learn from the testimony that we received from people all around the city with respect to their experiences and some of the things that they believe could have been better. And then we'll, look forward to having conversations and roundtables about how we would implement that in the state if it does come to that.
Assemblymember, one more question, and then we'll turn it over to Susan Lerner, who I'm sure will have a lot to say on many of these topics. Your colleague, as you mentioned, Senator Myrie, issued a really thorough report on Monday talking about a roadmap for election reform. For a long time, the Assembly was leading a lot of election reform issues for many years until Democrats took control of the state Senate. What's the appetite for some of the reforms within the state Assembly, including potentially reimagining the New York City Board of Elections with fewer commissioners?
Well, there are bills. I believe there are bills that are, I want to say Assemblyman McCourt, but I'm not sure who the Assembly sponsor is. I have to take a look again and see, but there is a conversation which is afoot. We know that the legislature is a bicameral institution. And so there's not much that, the Senate can do without the support and work from their Assembly colleagues. And trust and believe, just as we have been partners in government doing early voting and online voter registration, AVR, and all of the other progressive reforms that we have been able to accomplish as a body, I don't believe that we are going to leave reforming the Board of Elections on the table. So we will be in conversation and have been looking at bills to address the necessary reforms that would be required in order to have a full and fair implementation of elections. I believe it's something that, we are all looking forward to. But mind you, the Democratic Party is not a monolithic community. And I think election law is probably the one place where in the Assembly, we have 150 experts. And so trying to draw all of these individuals to get behind one particular thought is like herding cats, but I think I'm up for the challenge. And if they're giving me any trouble, then I'll just, go get my brother Zelnor and I'll put him on them.
Thank you so much, Assemblymember. With that, I want to turn it over to Susan Lerner from Common Cause. Thank you, Catherine, for this wonderful agenda.
Thanks so much, and apologies for racing in late. I was at the redistricting hearing in Brooklyn, and it takes a little while to get from Medgar Evers up to Midtown. So much has been covered. A couple of things before that I want to react to. I totally agree with Marty. I have thought for quite some time that our election code needs to be rewritten from top to bottom. But very interestingly, when there are conversations with members of the legislature, they say things like, wouldn't it be wonderful if Common Cause or the Brennan Center rewrote our election code? Well, we're a staff of between 3 to 6 people, depending on what's going on. And I am not really sure how many central staff there are in the legislature. Wouldn't it be wonderful if there were an entity that were charged with understanding and writing the laws? I wonder who that might be. Yes, it's a big task, but there is no question that there is a predilection on the part of our legislators to, as Marty said, just pick and choose parts of the election law which have come under scrutiny, gotten some kind of publicity. Let's change this, and hopefully bill drafting runs it through the computer and finds all the places where that phrase or that election law section is listed and adjusts it, but it's not a unified whole. And too much of it has been written in the 19th century. And we really need to sit down and think, how do we have a unified system of election laws, which gets us into the whole question of who is administering our election law? And are we comfortable in a 21st century technology situation with a bottom-up election administration, which is what we have here? What Marty was talking about is very much top-down, more akin to a Secretary of State system. And, you know, there's a lot to be debated in that regard, but certainly having a harmonized, unified, up-to-date election law would be very, very helpful. I want to introduce the question of election security and election equipment, which is very high up on Common Cause New York's priority list. I've got two specific bills that we're interested in, and it really has to, and I think some of the things that have been mentioned in terms of updating administration and the challenges of having at least borough-wide early voting, the excuse is always, well, the equipment isn't up to it. But there are, I'm aware, there are new possibilities for ballot marking devices that I believe are going to go through the certification process. There are other technologies which we can debate whether we like or not that are going to go through the certification process. And I believe that the certification process needs to be reformed. Our state board needs more flexibility. Our state board needs standards which are more contemporary. It's something that we're struggling with at the federal level, where the standards are being modified. And I believe that we need to completely reverse the balance of power in the relationship with the vendors. If we are not going to have our own state developed and owned election technology, which personally I'm a fan of, then we have to ensure that the election technology which is being provided by private companies satisfies the requirements of our election administrators and not the profit margin of the private companies who have an incentive to cut corners, not to really invest in radically new and different technology, but rather to build on the platform that they already have and to try and sell what is going to be most profitable to them. And I believe that the hybrid voting machines are an example of a situation where the election technology companies have come up with an extremely expensive but very profitable technology, which they are pushing very, very hard. And it is not a situation that we at Common Cause are comfortable with. We believe that there need to be requests for proposals and there needs to be a much greater specificity given to the vendors rather than the vendors showing up and saying, hey, we got this great new thing we came up with and it's going to cost you 3 times more than the equipment you've got before, but it's great, it's shiny, it's new. And I think that the state board needs more flexibility to determine whether or not to certify machines and not just a mechanical checklist. And that which I think goes into the BOE reform. I do agree with Marty that the New York City Board of Elections is a wonderfully attractive pinata for every single elected official. There's a lot to criticize. We have sued the New York City Board and have seen firsthand some of the inefficiencies, but it's much more systemic, I believe, than related to any one person. And it's really easy for elected officials, for instance, the Democratic county chair of Brooklyn, who might actually have some ability to change who's on the Board of Elections, taking swipes now in the press at the Board of Elections. They're a really bizarre situation. So BOE reform is very high up on our list, and I think that it needs to be a very serious discussion. It's not just changing the commissioners, although the commissioners, I believe, are a significant issue. It goes to the entire question of uniformity and supervision. The central staff, I have found, to my surprise, has relatively little control over what happens in any one of the 5 boroughs. And we saw that all too graphically with the infamous purge of Brooklyn voters. Where when we sued about that purge, what we found is that there really was no centralized management plan for how to maintain the voting lists. We ended up having to write a basic management plan in a settlement document in order to have some centralized control. So some of the things which are in the Liz Kruger bill, as it's been modified, I think are very interesting in terms of trying to allow there to be more direct accountability among the boroughs and up to the centralized staff. If they're the people that are going to be yelled at, then they ought to have the ability to actually control things. And we also believe that it's important for us to be talking about how we improve access to the ballot. Very happy to hear Assemblywoman Walker talk about bringing back the 2 constitutional amendments, which surprisingly failed on the November ballot. I think that having no fault absentee is extremely important. And unless there are changes in the law, starting January 1, 2022, voters are going to be very surprised about how hard it is once again to get an absentee ballot. And we are, of course, supportive of the John Lewis New York Voting Rights Act. It's a big and complicated bill, and we look forward to extensive hearings and discussions about what's actually in it, so that, again, it's not something which just gets plopped into the election law without harmonizing with a lot of different aspects of that law. So I think there's a lot to be done. I think we've had a great start, certainly with our partners in the legislature, who have really been working hard, as Senator Myrie says, to move New York from last to first in election reform. But the system remains very antiquated. An 1890s approach to election administration ingrained in our Constitution and our law, and I think we need to be having much more active discussions about what the voter expects. Because unlike what Marty says, in my experience, voters are very engaged with what's happening when they go to vote. They don't know who to complain to. They don't understand how the system works, and they are definitely upset when things go wrong. I don't think it's up to the voters to know all of the ins and outs of budgeting. The whole question of unfunded mandates is for another day, but we are strong advocates, as we were when we were advocating for early voting, that the state has to help with the costs. And to the degree that there is more uniformity, I think it will be easier for the state to shoulder some of that fiscal responsibility.
Susan, I want to take a moment and go back to those ballot propositions and talk about why they failed, and which is something I think we could spend a lot of time talking about. But then also, what is the implication of the fact that there was such a deep-pocketed campaign to fight them? And is there a response? You know, are you seeing that people are willing to say, I'm going to invest millions of dollars to support democracy? Or are we only seeing it coming from one direction?
So from your mouth to God's ear, in terms of investments to support democracy, I think what was very graphically shown is that those who want to restrict access to the ballot and who frankly are interested in an anti-small d democracy approach to voting have a huge amount of money and great amount of passion. I think it's, you know, one can very much say that one super wealthy, hostile to democracy billionaire managed to defeat what are generally very popular reforms. If you ask people whether they want to be able to be able to have access to absentee ballots with a lot of confusion. And then, but the other thing that definitely I think was problematic, the tremendous imbalance in resources was very, very dramatic. But the fact that you can't figure out what's on the ballot is a contributing factor. And I think it's time for us to be having a discussion about plain language requirements for ballot referendum. Ballotopedia did an analysis and determined that you had to have a minimum of 2 years of college, and in some instances, graduate school experience, in order to understand the language that was on the ballot this past November. There's nothing that prevents us from having a requirement for plain language on the ballot, requiring some basic translation so that that would be uniform and available to people, and setting a standard that what is on the ballot should be no more complex than what an individual with an 8th grade reading capability would be able to understand. And I'm hopeful that we'll be having discussions with our partners in the legislature about exactly that change. It'll be a little challenging for the attorneys in the New York State Attorney General's office, but good practice for them in learning how to write English.
Thank you. Thank you so much, Susan. We're going to go back to one of our other virtual guests, Professor Edward Foley. He is a professor at Moritz College of Law at The Ohio State University. Welcome and thank you for your patience. We're so excited to hear from you tonight.
Well, thanks so much for having me. Let me load up my PowerPoint here. Just bear with me for 1 minute. I hope this will be, there we go. Can you all see the PowerPoint?
Great.
Excellent. All right. So I'm going to talk about ranked choice voting, which we already started to talk about a little bit. And I'm building off of what here in Ohio we view as this extremely prominent and for the most part, essentially successful experience that you in New York City had this summer with ranked choice voting. And, there are lots of parts of the rest of the country that are thinking about this reform for all sorts of elections. And we envision you in New York City becoming ambassadors to the rest of the country on this topic. And so what I'd like to at least raise with you tonight is the idea that as you play this ambassador role and you discuss ranked choice voting with your colleagues around the country, that you at least think about that there are other versions of ranked choice voting, and one might actually be a little bit better than the one that you use in New York City for reasons that I hope we can illustrate. So what I'm going to do here is take a hypothetical set of ranked ballots. This is simplified for purposes of illustration. And what I have in mind are U.S. Senate races in pivotal battleground states. So think North Carolina, you could think Wisconsin, and so forth. And I want to show how different versions of ranked choice voting apply differently to the same set of ballots and voter preferences on those ballots. So, and I'm envisioning that at least around the country, for a regular November general election, we've got a polarized electorate, and increasingly so. So, I'm imagining sort of 4 segments of the electorate, left or right, going from progressive all the way to what we might call Trumpian populist. And if voters are given ranked ballots, we can kind of imagine what their rankings might look like. So, let's take this first cohort of voter, roughly a third of the electorate, let's say, in a state like North Carolina, their first choice preference would be a populist candidate who's endorsed by former President Trump. And their choices, let's just assume, are relatively linear in the sense that they would like the progressive the least. And on the flip side of the political spectrum, imagine again another 30% who most prefer a progressive candidate in the election, whereas they would like the further to the right populist candidate the least. Now it's a little bit more complicated in the middle of the political spectrum. So there are going to be some who like a conservative candidate, the most, but not necessarily a Trump-endorsed populist, but for their second choice preference, they'd be loyal to their party and therefore, choose a Republican populist second and then, pick the Democrats down in the rankings. But there'll be some, sliver of the electorate that don't want anything to do with a Trump-endorsed candidate, and they'll cross party lines, so to speak, to rank a liberal Democrat, a moderate liberal Democrat second before a more right-wing candidate. Similarly, on the other side, there's going to be a cohort of voters who want a more moderate Democrat as their first choice, but they're true to party loyalty. They'll pick a more progressive Democrat second before they would vote for any Republican. But again, there'll be a small sliver of the electorate who don't want anything to do with what they consider socialist. They think of themselves as a moderate Democrat and would cross party lines for a more moderate conservative before they vote for anybody else. So again, this is a little bit artificial and stylized, but it's designed to illustrate a point. So how would these ballots be handled in the New York City system? New York City uses what in the election law world we call by the name of instant runoff voting. It's a particular type of ranked choice voting, but it's not the only type. And as I think all of you know from your familiarity with the system, it looks for which candidate has the lowest number of first place votes. So that's the liberal candidate here. It'll knock out that candidate and then redistribute the ballots that rank the liberal candidate first to whoever is ranked second on those ballots. So progressive candidate will pick up most of those ballots, but the conservative candidate will pick up some. And then you're going to look at what the tallies are after that first redistribution. Nobody has reached 50%. So once again, you knock out whichever candidate is in last place. That happens to be the conservative candidate here. And so, that's the person that's going to get knocked out next. And you do another round of redistribution. And again, going down in terms of the rankings, the populist is going to pick up ballots from these two cohorts of ballots, and the progressive is going to pick up a little sliver. And voila, we have the result of this particular election using the New York City method of instant runoff voting, where the populist, the most far-right candidate, is going to beat the progressive candidate in the final round, 52-48. So now I want to contrast a different version of ranked choice voting. And to do that, we need to first understand the concept of head-to-head analysis of the rankings on the ballots. Given these same preferences, these are the same ballots with the same preferences, we can look at each candidate paired against each other candidate to see which one is more popular with the voters as a whole. And it turns out, as it is often the case, that there's a single candidate who beats every other candidate in these head-to-head examinations. And you can think of that candidate for centuries. Election theory has identified that candidate as the one most majority preferred by the electorate as a whole, because a majority of voters want that candidate when matched against every other candidate. So how does that work? Let's illustrate that. So one head-to-head analysis will be the conservative versus the populist. To look at that head-to-head, we ignore the other two candidates, and we notice that the conservative is ahead of the populist on all of these ballots, not necessarily ranked first, but ranked ahead of the populist in this one-on-one matchup. The populist is only ranked ahead of the conservative on these ballots. So here, 68% of the voters prefer the conservative to the populist. Next head-to-head is the conservative versus the liberal. We ignore the other two candidates for this head-to-head, and we see this is a closer race, but the conservative is ahead of the liberal on these sets of ballots. The liberal beats the conservative on this other set for a narrow 52-48 victory of the conservative over the liberal, but the conservative still wins. And then on the third head-to-head that we need to look at, the conservative versus the populist. With these ballots, again, ignoring the other candidates, the conservative wins these sets, the progressive wins this other two set of ballots, and that's a 55-45 split in the entire electorate. So, you know, for purposes of this particular election, again, could be North Carolina hypothetically, the conservative candidate head-to-head is more preferred by voters than each of the other candidates. And so there is a version of, and that's called technically the Condorcet Winner after a French mathematician, but you know that we just want to use American terminology tonight. But as a result of that analysis, people have developed what's called a better version of ranked choice voting, and BTR stands for analyzing the bottom two candidates. This is very similar to what New York did, but just a little bit different. For each round, as we eliminate candidates, instead of just eliminating the lowest candidate, we're going to look at that head-to-head matchup between the two lowest candidates. And doing that will allow this candidate who beats all others to be maintained as you move through the elimination process. So let's illustrate how that works. Again, these are the exact same ballots, exact same preferences. So same initial first round, but instead of just knocking out the liberal straight away, we're going to compare the two lower candidates, liberal versus conservative. Again, you've seen this head-to-head already. Conservative beats the liberal narrowly, 52-48. So the liberal is going to get eliminated. That's similar to regular instant runoff voting that New York City uses. And we're going to have the same redistribution that we saw before. Now, though, it's not just eliminating the conservative. We're going to look at that head-to-head between the two lowest candidates. That's conservative and the populist. Again, you've seen that head-to-head. The conservative beats the populist head-to-head. So now we're going to eliminate the populist at this round of the analysis. And that's going to result in a different election in the sense that the conservative beats the progressive 55-45 using this BTR instant runoff voting. So different result. And the winning candidate is the one that more voters prefer in terms of majority analysis. So we can compare these two systems. They yield two different finalists. The New York City system yields the populist and the progressive as finalists. BTR yields the conservative and the progressive. And again, a different winner in the end. And the New York City method eliminates that candidate who was more preferred than any other candidate, whereas the BTR system preserves that candidate and allows that candidate to win. So just to wrap up, it's a small but significant tweak to the system that New York City has. You know, almost everything is the same. The ballots don't change. The voters' experience doesn't change. The voters do the exact same thing. Most of the tabulation process is the same with the elimination rounds. But again, we get a different winner because we get a winner that is more in keeping with what a majority of voters overall prefer. So that's what I want to leave you with to think about as you tout the virtues of ranked choice voting as you experience this past summer. Thank you.
Professor Foley, thank you so much. So as somebody who did a lot of stories this past year about ranked choice voting for the first time and continue to be learning a lot about it, listening to that explanation of your calculation methodology makes me, as a journalist who has to try to take that and simplify it for an audience, say, how do you distill that to voters in a way that they can understand? Because we have to be able to say it to them in a sentence, and we don't, you know, if you work in radio like I do, I can't give them a slideshow. So how do I explain what you just explained in like 2 sentences?
Yeah, well, radio is probably the hardest medium. I feel for you on that. And, you know, I think it's an important point. I was actually quite impressed with the number of news stories that I saw leading up to the primary. You know, I'm thinking about what the New York Times did on its website, and the Wall Street Journal did a version of this. I think Wall Street Journal used pizza flavors as an example. So, with any version of ranked choice voting, there is a learning curve. There is no doubt about that. And you have to ask the question for any new jurisdiction that might be thinking about using this, is one version of this harder to explain than another version? Is it harder to explain the elimination process if you're eliminating the lowest candidate versus, comparing the two lowest candidates? The comparing the two lowest is a little bit like the TV shows, if I'm remembering the right one, the Survivor, who gets voted off the island kind of thing. There's some studies that talk about the head-to-head analysis is actually more intuitive to voters who follow sports, because the head-to-head analysis is the equivalent of a round-robin sports tournament that many sports fans know from soccer or football or other kinds of sports. So I do think we have to pay attention to public understanding. The public needs to understand its own democracy. I 100% agree with that. And if you wanted to use the most accessible version of ranked choice voting, I actually think the round robin version is the easiest to understand. But the instant runoff version that New York City used has all the rage at the moment, in part because New York City used it. And so I think one of the fiduciary obligations of all of us as attorneys, as we talk about this, is if you want to try to sell instant runoff voting nationwide, you should at least know the properties that it has. And it does have this property of eliminating the candidate who is most preferred overall. And maybe that you should tweak the system to avoid that problem.
Professor Foley, thank you so much. I want to turn to our final speaker, and then we'll have one more round of questions with some of the other experts in the room. But Senator Zellner-Myrie, who just this week issued a 50-page report on election reform here in New York State. Take it away.
Thank you, Brigid. And Professor Foley, it's a sort of throwbacks to being in a classroom. I felt very, very much enthralled with the lesson. Thank you for that. Thank you to the Bar Association, to Chair Loving, to President Boston. I think you came with the energy in the beginning, set the tone right. So thank you for that. And of course to Brigid for moderating, my fellow panelists, and especially to my sister in government, Latrice Walker, who I think didn't sell herself enough, saying that she's new to the chairmanship, but one of the signature pieces of legislation that we passed, automatic voter registration, was her bill in the Assembly. And it was something that she fought for and was very much in the negotiations for. And so she has been an incredible partner thus far, and I know we will continue that. A lot of what I was going to say has already been said, and I, of course, support the agenda as laid out by Assemblymember Walker. I just want to say this at the outset. It's very easy for us in this election law space, because we live and breathe this, to be insular and to think in the minutia and in the detail, and not recognize how seminal a moment we are in this country. I am, to be frank with all of you, I am terrified about what we are seeing across the country. We just had individuals storm the Capitol of our nation because of elections. It was our issue. The issue that we live with was the source of a violent insurrection in January, and that has continued. It's been a slow burn insurrection by way of restrictions in the franchise, by way of statutes being passed by legislatures all across the country. So the integrity, the credibility of our elections here in the city of New York, they aren't just a local issue. We have been used by enemies of the franchise as an excuse as to why we should be restricting the right to vote. So I don't think it gets more important than us getting this right, and getting it right now. We are on the cusp of midterms. We, of course, will be having a presidential election shortly thereafter. And if we don't get our act together and remove the excuses and the ability for other people to point to us, then I think we're going to be in really bad shape. Let me also say that I agree with what Marty and Susan and others have shared about how easy a punching bag the Board of Elections can be. I have a profound respect and admiration for those who choose to work at the Board of Elections, for the senior staff there, for the people who work on the day-to-day. I don't think we appreciate that they worked during the pandemic. There were members of the New York City Board of Elections who died because they were working and trying to keep our democracy alive. And I think we need to honor that. And I think we need to respect that. But with all of that, there of course is room for improvement. And it is something that I hear from my constituents and I have heard statewide. We went not just here in New York City, we went to Syracuse, we went to Rochester, Westchester, and of course in Albany, where we heard from many poll workers, administrators, election officials, and of course voters who said that the system as currently constructed is not working. I'm happy to go into the details and the recommendations that we made. We're attorneys in this room. You will read it and offer commentary where appropriate. But I think we can all agree that the status quo is not serving the most important entity of this entire equation, and that is the voter. And so it is incumbent upon us, those of us who hold some expertise, I'm not sure I count myself in that group just yet, and those of us who make the policy, like myself and Assemblymember Walker, for us to deliver for the voter. Everyone here knows you have a bad customer experience once, you do not return to whatever establishment that is. We have too many voters who are having bad experiences. And if they're not having bad experiences, they're reading about it in headlines, and they are further discouraged from engaging in a right that protects every single other right. And so reforming the Board of Elections obviously is going to be a priority for us, but the bill that Assemblymember Walker and I carry, the John Lewis Voting Rights Act, is also paramount for the reasons that I stated at the beginning of this, and that is enshrining the protections for voters, centering their experience, ensuring that changes to the election law don't disproportionately voters that look like Assemblymember Walker and I, which historically they have. And I think it really has to be a civil rights issue. I'll close on this because I'm trying to be respectful of time. And again, happy to answer questions about specific recommendations in the report. A lot of people don't know, and here in New York, we profess to be the progressive capital of the nation. When we were restricting the franchise in the 19th century, we opened it up a little bit to Black people, but only if they had property. And of course, many didn't. Many folks don't know that there were some slavery abolitionists who, in order to get Black people property so that they could vote, bought a bunch of acres up in what is now Lake Placid and encouraged Black people from all over the state to come to that land for free, simply to give them the right to vote. That establishment was called Timbuktu. It is now mostly Lake Placid, and there's a small museum that pays homage to that. But I'm always reminded of that history, of the history of disenfranchisement right here in the state of New York, but also of the spirit of people who wanted to change that, but who had to go through hurdles, had to have the resources to do it in order to provide this essential right. I very much view my role as chair of the elections as one in that tradition of ensuring that as many people have the right to vote. That includes the administration of our elections, but also includes a number of the other things that we've discussed. And so I'm very honored to be in this fight with my colleague in the Assembly. And I look forward to us coming together as we have for the past 3 years in order to deliver for the voters.
Thank you so much, Senator. I want to pose a question to you. During one of the, Marty Connor's presentation, one of the points you raised was how severely underfunded the State Board of Elections and certainly localities are across the state. When you held your hearings talking to election administrators, one of the concerns that was raised by one of the administrators was that there has been too much reform, that they actually wanted a moratorium on reforms because it was becoming too difficult for them to administer elections given all the changes. I wonder if you could sort of address both of those issues. The reforms that the Senate have passed, since you've been in office, since Senate Democrats have had control, have required the boards of elections to operate differently, but they haven't necessarily come with an infusion of resources to support those efforts. So how can you, in your position, advocate for funding our democracy, not just making changes to the policies that impact voters?
Yeah, so I think Assemblymember Walker eloquently laid out the fights that we have put forth for more resources and the allocations that have been made just in this year's state budget. But I would note that for the past 3 years, the amount of money allocated for local boards has gone up each year through us fighting for more resources for the boards. We hear, Marty discussed that there aren't folks sort of beating down the door on this issue. My first foray into being chair of the elections committee was a meeting with the elections commissioners all across the state. And this was before I even stepped into the chamber. And the very first question was, what are you going to do to give us more resources? And so we have continued to fight for that throughout our time in the majority. And I think we're going to keep doing that. But there's also a piece of this, and we reference this in the report, where the state allocates money and then the county governments don't do what we have allocated the money for. And so this isn't just a sort of executive or state level question, because there are no direct lines of accountability, because the appointing authorities as it stands now are political entities. Local governments, I think at times, don't feel like they have enough say in the operations, so they don't want to give money as it should be allocated. And in fact, in some counties, there have been punitive actions by the local legislatures because they happen to dislike a Republican or Democratic commissioner, and so they've pulled resources from them, from folks who have needed it the most. And so one of the recommendations that we've made is that there be a requirement that any allocation made by the state to these local boards of elections actually flow to them. And I think that is something that we will discuss as a legislature and see how we can uphold that statutorily. But we wholeheartedly support giving more resources. I have often told my colleagues during the budget, if you think it's too expensive to fund our democracy, tell me what the price of a free democracy is. You tell me how much you think it's worth for us to have free and fair elections, and then we can have the conversation. And when it's framed that way, I think people are much more amenable to greater investments. But it does cost money, and it is something that we're going to continue to fight for as we have the past 3 years.
Thank you so much, Senator. And I recommend reading the report. There's a lot of great stuff in there, a lot of great work from your office and your team. I want to invite we have 3 individuals from the audience who are going to ask some questions. The first is Rachel Landy from Vote Early NY. Rachel? And Rachel's going to come up to the podium for her question.
Okay, can you hear me? Okay. Thank you so much for having me. And I'd like to commend Senator Myrie for the report that he and his committee put out this week. Now, putting both the constitutional amendments as well as any big, but certainly unlikely sweeping federal legislation aside, there are a number of small fixes the legislature could make to the election law that would have a significant impact on voters' ability to exercise their fundamental rights. Many, of course, are identified in the report. For example, the legislature could eliminate the 2022 sunset on being able to claim risk of contracting an illness to apply for an absentee ballot. They could also bring forward the registration deadline to the current 10-day constitutional minimum. And lastly, they could require the counting of any affidavit ballots cast in the wrong polling place, but in the correct county with respect to any races the voter would be eligible to otherwise vote in. This wrong church, wrong pew technicality, as we call it, resulted in the disqualification of nearly 14,000 votes in the November 2020 general election. And the most imminent and easy fix would be to canvass those affidavit ballots. Do you think that come January, it makes sense to do these things in advance of the 2022 midterms? Starting with Assemblymember Walker, if she's still with us, and Senator Myrie, and then would love to hear from the rest of the panel.
Thank you. And so I will say that we will definitely be moving to go closer to the 10-day registration period. I believe that we should have same-day voter registration. I believe it's one of the most unfortunate circumstances that we're not there. But I do believe that we will eventually get there. The crisis, I think, which was before us, wasn't necessarily appreciated in totality with all of the systems that are necessary and effective in order to make sure that this campaign was appropriately handled. But I think that, you know, it really just invigorated our fight to make sure that we go and get what we believe New Yorkers deserve. Wrong church, wrong pew. I remember this situation with respect to Hurricane Sandy or Superstorm Sandy, since I heard reference to it twice, where there was an order that says, you know, we know there was a huge situation here. Voters can vote wherever it is that they are. And people were coming into the poll sites where I was at from the Bronx who worked in Brooklyn, and they were able to vote for the governor, and they were able to vote for any of the other statewide elected officials, but they lost the opportunity to vote for their local elected official from congressional seats on down. And so what I think we are in the process of now in terms of trying to identify is what is the appropriate balancing test for being able to count the votes that people have cast and expect that their vote be counted in those particular seats. And how, you know, what is the balancing test between making sure that their vote is counted in that instance, but the fact that they would lose the opportunity to vote for all of those local elections. And I think that that's just sort of the conversation that we have afoot. Again, I really do promote on-demand balloting, on-demand ballot printing. And that way, no matter where you are, you get to vote for your city council member on up to whomever is our statewide elected officials. I am pushing very aggressively this particular piece of legislation along with the bill sponsors and one of my brothers from the New York Democratic Lawyers Council, Jared Berg. And so again, I don't believe that, that we are necessarily across the finish line yet. And so I look forward to working with Vote Early and all of the voter coalition members to really figure out how do we make sure that we are achieving this goal, but without disenfranchising voters with respect to all of the elected officials that they should be voting for. And then with respect to the elimination of the 2022 absentee ballot request opportunity, I think that's what one of the questions that you had. We're all looking forward to no excuse absentee balloting. And I think that that's the standard where we are at, considering this is where we can achieve at this moment. I don't believe that that's a lofty goal. And I believe it's something that's very achievable in the coming session. Thank you.
Senator Myrie, you want to jump in real quick?
Yeah, no, I just echo what the Assemblywoman said, and I think there was a question on the 10-day and getting as close to it as possible. And that's something that we support, and that the Assembly member also mentioned, I think, in her earlier remarks. And so all of these are things that hopefully we can get done sooner rather than later.
That's good. Pardon?
What wrong charge?
Yeah.
You know, it's interesting because obviously this wrong church issue has been around a long time, and the Court of Appeals in Paneo against Southern said wrong church is no good. And so as a matter of just vindicating the rights of people to vote, a lot of us have been in favor of changing that. But I observed something and it suddenly hit me. Another way to look at that problem is there's actually a bias built into that system. It's a partisan bias, and in a lot of ways, a bias that it impacts minorities, racial minorities. Because, and it became really evident in the Brindisi-Tenney thing, because the only place we really saw wrong church ballots being thrown out was in the city of Utica, the city of Rome, not in the rural counties. And it hit me why. I have a place in the Adirondacks. There's one place to vote. There's one place to vote in the whole town. Nobody gets to the wrong polling place. You go to the town community center and you vote. It's in urban areas where you have the experience like I have where I live, where you walk by a polling place on the way to another polling place where you're supposed to vote. And so it's only in cities and densely populated villages, which tend to be Democratic, where you get lots of, as we know, lots, as the thing that Jared Berg came up with, lots of wrong church ballots and they're thrown out. That just doesn't happen in rural and primarily white Republican areas. So it's not just, oh, gee, every vote should count. It's like there's a real bias in that rule, a real partisan and a racial bias. And people ought to start looking at it that way and talking about it that way. Maybe we'll get more reaction out of the legislature.
And often it's not the fault of the voter. The voter will go to a polling place and then they'll be, and this is something we would see on the national hotline. And when with election protection, that a voter would be sent to 2 or 3 different wrong polling places. They wanted to vote. They were willing to tromp around in the cold or the rain to different polling places. And by the 3rd one, they were giving up. So I'm also hopeful that technology with the electronic poll books can help put a stop to misdirection of voters.
You know, I also want to note, I guess, if I could, that one of the problems that we saw in the most recent election was that many of the poll sites were changed without enough time for the voter to be notified. And so the notice requirement that was there just simply didn't exist. And so I think that there are some things that, you know, we can do intermittently in order to make sure that, you know, many of our voters who are given either misinformation, wrong information, or late information actually are able to get, you know, sort of the information a lot sooner. We were fighting even to just get an appropriate display of where your correct voter, where your correct poll site is located when you show up at the wrong site, because a lot of our poll sites were changing based on COVID and meeting nursing homes, et cetera. And so I think that, you know, going also back to the Board of Election Reforms, that this is also one, these sort of same day or eve of election day bait and switch to, initiatives. I think just there needs to be an end to it.
Kate Doran from the League of Women Voters. Thank you so much, Assembly Member. Come on up and ask your question.
There we go. Thank you very, very much for inviting me to be here in this distinguished company. It's, it's very, very important for all of us to be talking about this. I very much appreciated Senator Myri's report and his comment that the January 6th insurrection was related to our issue. That's extraordinary to think about. I'd never considered that before, but that is the truth. As Brigid mentioned, I'm with the League of Women Voters, and we've been around for over 100 years. And one of the other connections I wanted to make with what Zellner Myrie said was he talked about serving constituents and what any of us might do if we go to a place where we expect to be served well and we have a terrible experience. It's going to be very hard for us to embrace that experience again. Now, we have always been all about serving voters and getting out the vote. That's who we are. So my question for everyone on the panel is, of all the recommendations we have heard and all of the priorities that you have put forward, what would you do first amongst those recommendations and priorities? And how do you draw a line between that thing that you would do first and serving the voter and getting out the vote? And I would love to hear from everyone and anyone on the panel. Thank you very much.
Maybe let's just start with Doug because he's down in the end and we'll work our way down.
There's no one solution. That's the whole point that Senator Myrie's report made yesterday, which is that we've done a lot of major changes just in the last 3 years, but we're not finished. And all of these things we've talked about tonight are important. And I think it's very hard to prioritize or pick out one and say it outshines the others.
Well, this is asking who's your favorite child. But if forced to pick only one, I would start with moving our voter registration to 10 days. In light of what, Kate, you pointed out is the League's devotion to turning out the vote. What we know from other states is that it's extremely difficult. There is no magic silver bullet to increase voter turnout, but we have documented proof that the combination of early voting and a registration deadline that overlaps, and we would have one golden day if we moved the voter registration to 10 days, does reliably increase voter turnout, not by leaps and bounds, but by a cognizable, not insignificant amount. So I would start with moving our voter registration off the 25 statutory deadline, 25-day statutory deadline to the constitutional 10-day deadline.
I look at it, I don't want to beat a drum again, but I think to do all these things, you have to go back to what kind of election administration system you have. 10-day registration is fine, but that implicates a lot of administrative. Now, somebody registers 10 days before the election, that's during early voting. So you got, okay, so does that mean the next day they want to go and vote? And is that registration that they timely handed in 10 days before the election, is that going to be in the system when they show up the next day at early voting site to vote? And how's that going to happen? And who's going to do that? And do the boards of, and remember, we're not again talking, a big board like the city board will just put some people on it because they can move people around. One of those little boards is going to be sitting there going, wait a minute, the four people who work at the board are out at their one early voting site in that little county. So who's handling the voter registration that came in 10 days before? And how is that getting in the electronic poll book 9 days before so that the people can vote when they show up at early voting. I mean, that's what I mean about when you change things, you have to look at everything that follows from it and related things. And
yeah,
and back to resources, that 4-member board is never going to get that done. They're never going to get that done.
So, I mean, one of the things that having that deadline allows for is a form of polling place registration. And in changing the deadline, one would need, you know, recognizing the overlap, one would need a procedure for what happens when the voter presents themselves 10 days before the election on the first day of early voting. And certainly at Common Cause, what we would recommend is that the voter would cast an affidavit ballot, which based on the change that we made in 2010 is a voter registration form, and that voter would not vote on the machine. Obviously, that would increase the number of affidavit ballots, and there would have to be administrative adjustments for that. But I think if somebody's at the 10-day deadline, the likelihood is that they're coming in to a polling place, and they can be directed to a polling place.
Right, and I would agree that the affidavit ballot's the way to go, because once upon a time there was a reform about enrollments back in the late 70s. And I was involved in an election where we found the new rule was, oh, if you hadn't been registered before, you could register and enroll, and your enrollment counted immediately. Didn't have to go past the November thing, which was upheld by the federal courts in Rosario. And in an election in Brooklyn, we found 300 mail check cards coming back in October while we're contesting the election that sent detectives out and found out these 300 new registrants and enrollees who had voted in the primary, where the margin was 100 votes, were all from vacant lots and gas stations and whatever. You can read it. The judge throughout the whole election. It was rerun. So, you know, I'm not one. I don't think there's a lot of election fraud, but if we make it easy, somebody will game it, and we have to prevent that. So, you know, when somebody shows up 10 days before the election in the poll site and registers, to let them register on a machine and then find out there's no such address is not a good idea. If they do an affidavit ballot, you can check it.
That's exactly right.
I want to invite up Larry Norden from the Brennan Center for our final expert question.
All right. Well, first of all, thank you, Brigid, and thanks. It's great to just see so many friends who are so smart about elections, engaged in such a rich conversation. I particularly wanted to thank Assemblymember Walker and Senator Myrie for all that they've done over the past couple of years to bring New York election law into the 21st century. Senator Myrie talked about the moment that we're facing right now in the United States. And I can say, as a part of an organization that fights voter suppression laws around the country, that it wasn't helpful to show up to court in North Carolina or Georgia and have the immediate response be, well, New York, you know, when we're talking about cutbacks on early voting or voting on Sundays, New York doesn't allow that. So what does it matter if Georgia is cutting that back or if North Carolina is? To comments that a bunch of people have made, whether we like it or not, and most times it's probably a good thing, New York is kind of at the center of the media world in this country. And when there are snafus, when there are administrative snafus in New York, they're picked up everywhere. And in fact, Marty talked about, you know, what was the big deal with the votes being inaccurately counted initially in the New York primary. But of course, our former president jumped on that to attempt to undermine all elections in this country. So really is so important what we do here in New York. I also just wanted to congratulate Senator Myrie, as many others have here tonight, for his report. It was so excellent, and I really have appreciated all that his committee has done to hold hearings around the state, about administration in the state, and for recognizing in that report that the administration of elections is the other half of the battle. That it's certainly we've got to pass laws that increase access, but if you have poorly run elections, then you're not going to get as much access as we all want. So leading into all of that, I'm hoping that Senator Myrie and Assemblymember Walker and anybody else who wants to jump in can talk about what they see as the prospects for real reform to administration in New York, the kinds of things that Doug talked about, reducing the number of commissioners in New York City, but also giving the state more power over the way elections are run, more uniformity in the way that elections are run, so we don't have the kinds of situations that we did in Congressional District 22 with every county doing things differently and counting votes differently. Assemblymember Walker talked about this a little bit, but where are your fellow Democrats on this? Do we know where the governor is on this, and what kind of priority she may give to this? And what can we do? So you know, I work at the Brennan Center. Susan is at Common Cause. We're part of a Let New York Vote coalition to try to push for these kinds of changes. How can we help you make these changes happen?
All right, so I'll take this one first. You know, I think the Assemblywoman aptly explained that the uniqueness about election law is that every legislator has had to go through an election. And so they all have their own opinions on how they should be administered and how we view the franchise. And so that does make things a little more difficult. I think that we have proven over the past 3 years, close to 80 changes to the election law, that this is something we stand ready to engage in a pretty serious way. I don't think that BOE reform is going to be an exception. You know, one of the beginnings of the report states that this recommendation and all of the sort of prescriptive things laid out, they're not meant to be the end of the discussion, but in fact, the very beginning. And a lot of the report synthesizes what we've heard, not from fellow legislators, but from the public and from stakeholders like yourselves and the organizations. And so I think to your question on where the governor is, where our colleagues are, I think that is going to be the subject of conversation over the next couple of weeks. And certainly when we return to session in January, if the past is prelude in any way, I think that we are going to get a lot done together, but it is going to take, you know, there are some extra sensitivities when it comes to reform. There are, of course, a lot of thoughts and opinions about who should be influencing which process. And that, you know, if we're being honest, it is political, and that is going to require a different level of political will or a different type of political will than we've seen in the past. But I'm hopeful, and mainly because I have a really good partner in the Assembly who is smart and thoughtful in her approach, not just on the substance, but on how she talks to colleagues.
Awesome. Thank you, Zelnor. And, you know, it's, you know, I remember even just having a number of conversations about reforms to our election process. And it's worth noting that we have to go to people whose livelihood is dependent upon things sort of existing in a certain way. And they've learned that way. And they, you know, to a certain extent, you know, I remember someone told me that, you know, it's a reason why they call it political science, because it's science, it's not art. And when you sort of feel like you've learned the science of it, there's a certain want to be stuck there. And so, you know, it's not easy to bring our colleagues along. But this is a new day and a new legislature. And everyone is, you know, sort of innovative and progressive, and they want to get things done, and they want to get things done very quickly. And so I do believe that we are going to get there on the election Board of Election reforms. One of the things, you know, as a voting rights attorney, and hearing that, you know, you are as well, what makes sense, or sort of maybe didn't make sense, is, you know, New York State was a Voting Rights Act of 1965 covered state, at least many counties were. And so people didn't believe that sort of the injustices that exist in the Deep South, you know, were present here in the great state of New York. And, you know, hearing of all of the administration inadequacies at least says to me, and I didn't get an opportunity to answer what would be my number one thing, and it is of course passing the John Lewis Voting Rights Act, because it will help us in order to meet the formula requirement for the Voting Rights Act federally, because we will be able to lift up so many of these injustices and inadequacies of our election administration to say that we need to remain a covered state and extend from counties and make this a statewide issue, as we've seen and evidenced by Marty Connor's testimony about Utica, New York. And so from Utica Avenue to Utica, New York, there's some issues that are afoot. And this is a civil rights issue of our time. And I think that this is the proper moment by which to address it. So I am confident that we'll get there.
Assemblymember, I really like that from Utica Avenue to Utica, New York. So I may have to find a way to put that into a story at some point. Credit to you, of course. But
at least for the first, I think they say 3 times the pastor say.
But I want to just tack on part of Larry's question as the follow-up, which I think you're getting to, but what can people in this room do to support whether it's pushing for BOE reform, as well as the John Lewis Voting Rights Act? What more can people do to support you and Senator Myrie to get some of this stuff done?
Well, I think at least as, you know, one of the things that I'll point out to say, you know, again, we're here in this amazing forum, and we don't represent a diverse even panel, and the folk who are asking the questions, you know, didn't reflect the diversity of the legislature. And so we have to make sure that, you know, we are only as good as our most previous election. And that goes for myself, that goes for Senator Myrie, and it goes for all of our colleagues. And if we aren't raising these issues to our constituency and including them in the conversation and in this advocacy, then it becomes an issue of them over there, right? And so I will say that we have to have a more progressive and diverse coalition. Of course, the CLSJ, the Center for Law and Social Justice, is a huge partner, and I'm sure it's very difficult that this conflicts with the Brooklyn redistricting hearings. But we have to do better to engage more people of color. The most tried and true voter is a Black woman over the age of 55. And those voices have to be lifted up. And so, you know, I'll just say that from my perspective, I think that we have to talk more to our sort of everyday colleagues and sort of, you know, land the plane a little bit in our home districts.
Senator Myrie, do you want to add anything to that as well?
Nope, I think she captured it perfectly.
Great. Did anyone else on the panel want to respond to that?
Thank you.
I think I have the privilege of thanking everyone for all of their expertise and sharing it here tonight. Lots of great ideas. Very excited to see what the new session holds. And thank you so much for joining us.